friends. Today we shall discuss the National Commission of Backward Classes, a new series related to constitutional bodies that I am starting. So we shall cover these points in our this lecture. These include the historical background, constitutional provision related to National Commission of Backward Classes, what are its functions, powers, and then we shall analyze the news for which we are discussing the NCBC, as well as what new development has taken place recently related to NCBC. So this is the news for the reason why I picked up NCBC as the topic of discussion for our today. In a mission to trigger review of the state OBC list, that means OBC lists are prepared state wise as well as center wise. This means that uh, in case of Odisha, we have a separate list of OBC for a center and separate list of OBC for state. So this is what it is discussing here. In mission to trigger review of state OBC list, NCBC hits a wall of absent. That means a dead end of socio-economic data. We will see what this news means, but this is the reason why you in day-to-day life you come across that there are some candidates who come in the OBC list of their own state, but they fail to come in the OBC list of center and vice versa. Fine. So this is the historical background under which the NCBC evolved. Under Article 340 of the Constitution of India, first backward class commission was appointed under Kaka Kelkar in the year 1953. We must remember the first Lok Sabha election results were declared in the year April 1952. This is required when chronology plays a very important role in exams conducted by UPSC. We can eliminate options using these chronology. Fine. These are being done under the objective such that socio-economic justice can be provided to deprived communities. Socio-economic justice. Fine. So, so it must have given certain recommendation. Then later, second backward class commission was appointed under the chairmanship of BP Mandal. This was done under the premiership of Moraji Desai in the year 1979. You must remember this was the period when tussle was going on inside the Congress, and Janata Party has formed the government for the first time at the center. The Mandal Commission then submitted its report in the year 1980. Fine, there were a lot of hue and cry and protest which was organized around the country based on because of the recommendation which the commission has provided, the recommendation which the commission has provided, and the way OBCs are included in central list, that I shall discuss in a separate video. This particular video is specifically related to National Commission of Backward Classes. Fine. Later in the year 1990, the VP Singh government, which was formed under the National Front government, it showed its intention to implement the Mandal Commission recommendation. Fine, this was done in the year August 1990. Chronology is very important here. And finally, the recommendation of the commission was gradually implemented. It was gradually implemented, and it was later upheld by the Honorable Supreme Court in the Indira Sahni case. This is why Indira Sahni is important case in the year 1992. One more thing which was detailed in the Indira Sahni case, it was that point which was detailed in the Indira Sahni case was that a ceiling level of 50% has been fixed at the 50% reservation has been fixed. Fine, not more than 50% reservation can be given. That these 50% include the OBC reservation, SC and ST reservation. So this ceiling which we generally come across of 50% reservation, this has been fixed in the Indira Swani case. Fine. As well as in this case, the Honorable Supreme Court directed the then government, central government, to form a national commission for a body to look after the inclusion or exclusion of these communities and their welfare. So accordingly, the central government formed a National Commission of Backward Classes. An act was passed, obviously, and then a statutory body was appointed, formed. Fine. So this is a statutory body because at that point of time it was a statutory body because it was formed under an act. That is why it is called a statutory body. It was formed under a statute. Later in the year 2018, under the 102nd Constitutional Amendment Act, the status of NCBC was raised to the level of a constitutional. So now it is a constitutional body, unlike earlier when it was a statutory body. Additionally, now all those powers which were given to National Commission of Scheduled Caste and National Commission of Scheduled Tribes, those all powers have now been conferred upon National Commission of Backward Classes. Fine. So let's talk about the constitutional provision. So the 102nd Constitutional Amendment Act of 2018, it inserted one article 338B which provide for the constitution of NCBC, its power, its function, and the report that it submits to the president and the state government, as the case may be. We must remember, as I told you earlier, that prior to NCBC there was National Commission of Backward Classes as a statutory body which was doing this job. Fine. Additionally, which one more thing which I like to point out, that in the article 338 which is related to National Commission of Scheduled Caste, it has been mandated to do similar job, same job in fact, to discharge same function with relation to OBC and Anglo-Indians, which NCBC has been doing with reference to has been doing with reference to scheduled caste. This was provided in article 338 clause 10, if I am right. Fine. If we talk about the constitution of the commission, it includes a chairperson, a vice chairperson, and three persons. This is provided in article 338. Fine. They are appointed by the president under the warrant, by a warrant under his hand and seal. As you can see it, the present chairman of the National Commission on Backward Classes, Shri Gangaram Ahirji, he is holding that very warrant, which has been signed by the Honorable President of India at that point of time in the year 2022. Fine. The condition of service and the tenure, they are determined by the president. So at present it is 3 years, but what is important that they are determined by the president. If we talk about the functions of the commission, the first and the primary functions which it has to discharge, that it has to monitor and investigate all the safeguards that are provided to socio-economically backward classes under the constitution or under any other law. We must remember, in common parlance we use the word OBC, other backward classes, but constitution uses the word SEBC. Fine. And this is it uses at several places, especially at article 342A, and also in article 366 item number 26. It uses this very word, socio-economically backward classes. Fine. So what all safeguards that are provided to the OBC community? So we must remember a constitutional safeguard. So under the article 15 clause 4, it has been provided that if reservation is provided for the advance, if special provision, and more specifically if we talk about affirmative action, that is reservation, they are provided to socio-economically backward classes, then they should be provided. If they are provided, then to what extent they are being implemented and how the communities have benefited from it, the reservation that are provided to them for the in the educational institutions, how effective it is. So it is provided under article 15(4) first, and then under article 16 clause 4, the special provision or reservation is provided to them for their representation in services of the state. Fine. So they are, so under these two articles, that is under Article 15.4 and 16.4, they are provided reservation in educational institutes, for example IITs, medical institutes, and also in services. So this is being done in order to provide social justice, what even our preambular justice which we talk about, so that marginalized communities can be brought back into the mainstream of the country. Fine. And then what other function it discharges, that it inquire into specific complaints of deprivation of rights or safeguard. Fine. Whatever, if right and safeguard those are being provided to the backward classes, is it being fulfilled? And if any complaint has arisen, then those complaint can be filed and it can investigate those cases. Moving forward, the socio the commission, it evaluates the progress of the various communities. We will see that this very point has been the basis for myself picking up the news related to commission at this point of time. Fine. And this evaluation is done both for a state and center. Further, it makes recommendation to the union and then to the state for the socio-economic development, for their protection welfare measure of the of our OBC communities. And finally, it does any other function which the president can allot him for the welfare development of and advancement of the socio-economically backward classes communities. Fine. If we talk as far as the report which the commission presents, so commission can present an annual report. It has to present an annual report to the president, or it can present a report at any point of time when the need arises. That is when president can demand it. Fine. The report which is submits, it has to be placed before the parliament. President has to place it before the parliament, and parliament has to provide a memorandum of the steps that it has taken in order to implement the recommendations of the commission, as well as if it fails to implement any of the recommendation, then it has to file a non-acceptance of the memorandum, the why it has not implemented it for certain reason. Let's say for conflict may arise if that particular recommendation is being implemented, and whatever be the case, it has to file that the reason for its non acceptance. And similar is the case with the if if the report, the president also forwards the report to the commission pertaining to a state government. Fine. And to the state government as the case may be, and same is the case here. The government has to place the report before the state legislature with a memorandum of action taken on the recommendation and reasons for non-acceptance of any such recommendation. Though that means is that same procedure that is being followed. What is important here, that commission submits its report to the president, which the president places it before the parliament, as well as the president, if any information related to the report is present in the pertaining to state, then president then forwards the commission report to the state government. Fine. Not to the governor. If we talk about moving forward to the power of the commission is vested with the power to regulate its own procedure. Fine. That means it is not governed by code of civil procedure. ठीक है. The commission, while investigating any matter or inquiring into any complaint, has the power of a civil court. The power of a civil court has been provided. It is a civil court where suits are filed, fine, and disputes are resolved. So what all are the powers of civil court? So these are the powers of civil court, that it can receive evidence on affidavit, fine, it can require the discovery and production of any document, it can requisite a public record from any court or office, it can summon and enforce attendance of any person. Fine. It can summon then examine the witness. It can examine the witness. Fine. As we see in the movies, that witness who are standing in the court, they are examined by the lawyers. So same procedure it can be followed, since it is acting like a civil court. And documents, it can check the correctness of the document and any other matter which the president refers to him. Additionally, there is one line which is written here which is important. The central and the state government are required to consult the commission on all major public matters, ठीक है, affecting the socially and educationally backward classes. So it is written here, the center and state government are required to consult all the commission for all the policy matters. It is saying that if state government is including any community into the state list of backward classes, then it has to consult the commission, which we will later see that this is not the case. We will later come to see. Fine. This line has been picked from Article 338 B clause 9. So this is the news which we were discussing. There's the power that was provided, as I already talked about earlier talked about. This was the function of the commission to investigate and monitor all matters related to the safeguard provided to the SEBCs under this constitution, or and evaluate their working. Fine. And to advise socio-economic development of SEBC, to evaluate their progress. So this by this news, I wish to draw your attention that at this point of time, National Commission of Backward Classes, they are exercising their power they granted to him under the 102nd Constitutional Amendment Act, and they are questioning the state governments, specifically states like West Bengal and Karnataka, that under what basis are you continuously including certain communities? A large number of communities have been included to the OBC list. On what basis are you including? How can you show a basis that they are actually deprived communities of which are being included into the state list of OBCs of socio-economic and educationally backward classes? Can you show any documentary evidence? That means it is acting like a civil court at this point of time. This is the power that is provided to him. And specifically this question has been raised to the West Bengal and Karnataka, and later which we see, and this is the reason why the National Commission of Backward Classes, it has put on hold the proposal for including the 80 of the states communities in the central list, because it has demanded states to show the documentary evidence that why these communities, if they are actually deprived, why, if they are deprived, show them, show us the evidence, so that if required they can be included in the central list of OBCs. But states have failed to provide any data, the basis of marginalization or the deprivation. And the state have cited one reason, especially West Bengal, where it has said that it is when the very first time the decision is taken to include them in the state list. At that point of time, had you asked for the data, then we could have provided you, but not now. This is in clear violation of the power that is given to the NCBCs when it acts like a civil court. We will see. We will later see. We will see in future what action NCBC takes uh, against the state government, because it is clearly mentioned here that it can requisition any public record from any court or office. An office, state government offices, or obviously means office under these very power of the commission. Fine, we'll later see what commission does. However, what one more conflicting issue that has come here, that lack of socio-economic data has been cited as the basis why the state has failed to show the any basis of deprivation. Fine. Last socio-economic caste census was conducted in the year 2011. and though it does not have any legal basis, it does not have provided it it lacks any legal basis. Fine. First socio-economic caste census was conducted in 1931 under the British regime, and then it was conducted in the year 2011, and that is why the continuously certain states and political parties are demanding to conduct a national level socio-economic caste census, so that we are able to generate actual data on the of the deprived communities, of the socially and educationally deprived communities, for other communities, so that actual data can be collected, and thereby policy formulation can be done, so that their upliftment can be effectuated, and they can be brought into the mainstream of the country. Fine. So this is the news piece as of now. Fine. And what I was talking about, the recent development related to the commission, that in the article 342A of it is provided that the president alone can notify caste as a socially and educationally backward class with respect to the state and parliament, and fine, with respect to the state, and parliament alone can modify it. No power has been given to the states under the constitution, and this was provided in the 102nd constitutional amendment act that we recently saw, which was passed in the year 2018. So we are actually depriving states of its power to even draw state-wise OBC list. So this is something which raises our eyebrows. So this was actually observed in the Maratha reservation case by the Honorable Supreme Court. The Supreme Court ruled that it is only the center which has the power to draw up the OBC list as per the above interpretation. Fine, it is a parliament which passes which actually did the Constitutional Amendment Act, and Supreme Court only is interpreting. The Article 324A mentions only about the president and parliament and not of the state. So in order to reverse this issue and restore the power of the state government, the then 105th Constitutional Amendment Act was passed, so that state can be accorded their powers to draw OBC list state-wise by themselves, so that they can later and they can be notified by the assembly, that is the state assembly, and the role of president is not required, as well as the NCBC and the president, they don't have any role with respect to state list of OBC, or if you use this term, socially and educationally backward class. Fine. So this was a new development. Let's what we read. Let's test ourselves. So this is the question which I framed, and based on the new pattern. See, the functions, powers, and condition of service of national NCBC, NCSC, and NCST are provided by the government of India. Fine. This is the first statement. Second statement is the tenure for members of NCBC, NCSC, and NCST are provided in the constitution. ठीक. And third statement is the commission, while deciding the suits, has to compulsorily follow code of civil procedure. So this statement is wrong, since we have recently studied it. Rest of the two statement we will solve by our common sense and logic. Fine. As we saw that commission can devise its own procedure. ठीक है. If this statement is wrong, this means all three statements are correct. This is wrong. So only these ABC can be the answer. We must remember that NCBC, NCSC, and NCST are constitutional bodies. Fine. So the function, power, and condition of service, these will be provided in the constitution itself, rather than leaving them to the whims and fancies of the government of the day. Fine. This is the reason why these are called constitutional bodies. Their power, function, condition of service. Fine. They are provided in the constitution. In fact, condition of service is provided by for these bodies are provided by the president. However, the function and power, it is provided in the constitution. That is, so what is the thumb rule that for constitutional bodies, power and function will be provided by the constitution itself. So this statement is wrong based on the thumb rule. Also, our common sense says this: the tenure of the members of NCSC, NCBC, NCSC, and NCST is provided by the constitution. This statement is wrong because it is provided by the president. So little information, factual information you are supposed to know. Else, at least if we know if we use our common sense, because this was the factual statement within this we eliminated by common sense. So by this we can arrive till this condition, till this equation, that only either all are incorrect or one is correct. You can arrive till this equation. Fine. So this particular second statement you are supposed to know. They are formed by the president. So this is the correct answer. So the moving ahead solution is none of the statement correct. Explanation: for constitutional body is the president who decides the condition of service. Additionally, power and function are provided by the constitution itself. Fine. Under the rule, they hold office for 3 years. Mm, provided in the constitution, they hold office for 3 years. The commission is vested with the power to regulate its own procedure. Fine. So this is all which I wish to share. Thank you. Keep studying.